doing the poll?
Asta will be on to do the poll. So,
Okay.
Here we go. We've got people that are joining very quickly. So we can get started.
Great.
Why don't we give it like 1 minute so people can fully join on, and then we'll get started. If that works for you, all of you.
Great.
Once we get a critical mass, I'll let you know.
How many do we have?
There's over 50 people registered.
Oh,
So
wonderful.
I'm just trying to get to about 25, 30, and then we can get started, if that's all right. Just
That's
give it
great.
a minute or two. Yep, we're there. We can get started. Let me just check. The polls are set up. Just let me know when to launch them and I'll launch them, okay? All right. Hi, everyone. My name is Tara Ragavan. I'm the president-elect of the South Asian Bar Association of North America, and I welcome all of you here for today's webinar, 2022 Immigration Trends. And before I turn it over to our immigration co-chairs, two of our immigration co-chairs, who will introduce themselves as well as our esteemed expert on the call, Ira Kurzban. We're just wanted to let you know that there's two other events for SABA North America this week. The first one is tomorrow on Afghan resettlement in the US. How can you help? It's at I guess it's 6:30 p.m. Eastern, and then that's tomorrow evening. And then we also have the second part of our Black History Month book club. So you want to talk about race. That's happening on Thursday at 7:30 p.m. Eastern. And now I'll turn it over to Mala and Hemel to introduce themselves and Ira.
Hi, everyone. Welcome. My name is Hemel Vyas. I'm Immigration Section Co-Chair here at SABA.
Hi,
Go ahead.
I'm Mala. Oh, sorry.
I was going to hand it over to you.
I'm Mala Bajpai. I'm also practicing immigration law and another co-chair out on the West Coast in Arizona and California.
I'm going to start off with some statistics recently from the Smithsonian. There are about 23 million people of Asian or Pacific Islander descent in the United States, made up of 6 origin groups: Chinese, Indian, Filipino, Vietnamese, Korean, Japanese, which accounted for 85% of all Asian Americans as of 2019. These groups together largely shape the demographic characteristics of the overall US Asian population. In less than 50 years, nearly 1 of every 10 people in America will trace his or her roots and heritage to Asia and the Pacific, a region that covers more than 1/3 of the earth, including the Far East, Southeast Asia, and the Indian subcontinent and the Pacific. This reflects the immigration footprint of Asian Americans in US. So this is a very exciting session. We're going to have to learn about the immigration trends.
Great. Before we get started, we wanted to take a quick poll and see who's on the webinar. Are you immigration attorneys, non-immigration attorneys? If you could answer that for us real quick. I definitely, in the days leading up to this webinar, if I mentioned to somebody who's not an immigration attorney that we have Ira Kurzban coming on, they kind of give me a head tilt like, But if you mention it to an immigration attorney, it's like, oh my goodness. He definitely doesn't need any introduction. So let's see who we have on here.
Are you ready?
We're ready.
There you go. I'm
Where
going
are
to share
the
the results.
Oh,
Okay, you've got a good mix,
Wow.
Mala.
Yeah, 27%
wow.
non-lawyers. Okay. So to the 27 and 5% who are not familiar with immigration law, Mr. Kurzban is definitely the person who wrote the book on immigration law. It's an immigration source book. On my bookshelf, I have an old version, which is right here. I think Hummel does too. It's like
I have
over 3 inches thick.
There you go.
There you go. We have some old versions. Now we subscribe to the online version. But Ira Corspann's degrees and accolades could go and fill the entire 90 minutes, but he's been practicing for over 30 years at the top of immigration law, and according to National Law Journal, one of the top 20 attorneys in the country. He's litigated over 50 federal cases concerning alien rights and argued more immigration law related cases before the US Supreme Court than any other private practitioner in the country. So without any further ado, I would definitely like to start the conversation with Ira. If you could somehow encapsulate for those, especially non-immigration lawyers, kind of what's been happening in immigration law the last 4 to 5 years. Where were we? Where are we now?
Great. Well, thank you, Mala. Thank you, Hamel. And I really appreciate the opportunity to speak to everyone today. What I'm going to try and do is kind of give an overview of where I think we're at from the Trump era to the current situation in immigration, and try and hit on kind of different areas of immigration law. But as we had talked about before the call, anybody who has any questions, of course, please feel free to ask them. And at some point, my wonderful host will tell me to stop talking and try to answer some questions. So let's go back to, where I think we were originally. I have a particular view. I'm not sure it's shared by everyone, but I honestly believe that the last administration was attempting to crash the entire immigration system. We heard a lot about the wall. We heard a lot about the Muslim ban, but their actions were extraordinarily pervasive in every single area of immigration law and in visa issuances and the Department of Labor, et cetera. So, we started out with the presidential announcements, obviously, the president's Muslim ban, his statements about hiring Americans. The implication was hiring Americans only. His health insurance ban, which was clearly designed to end a good part of lawful immigration into the United States because of the way it was structured. His various other proclamations about travel bans, his institution of Title 42 at the borders of the United States, they were all designed really to kind of lock in this vision of America as independent and separate from the need to have any immigrants in the country. He, of course, made statements about Muslims. He made statements about Black refugees. He made statements about Asian Americans. And in fact, at one point, we ran an ad, for Immigrants List, which is an organization I'm involved in, called Words Matter. And you may want to look at that because it's about how Trump talked about Kung Flu and used COVID-19 as a dog whistle to be basically anti-Asian. And we pointed this out in an ad and what it meant and what the effects were. And as you all know, I'm sure, how it's affected people in the US, people were attacked and so forth. So this is a very comprehensive plan not to have people from Africa, not to have people from Asia, not to have people from Latin America. Trump was kind of the band leader. But while that was going on a kind of national level, Stephen Miller and others who were very familiar with immigration law, and I have to tell you, I've been doing this a long time, too long probably, but this is the first group of people who came into the White House who were not only anti-immigrant, but knew exactly how to crash the system. And obviously, on the regulatory front, they were doing that by the public charge regulations, by the asylum regulations, by changing H-1B regulations, all of which were designed strategically to make it more and more and more difficult. On the administrative side, they were making changes in EOIR. They brought in, for those of you who may not know the history, a number of years ago, when President Bush was president, Ashcroft fired the 11 liberal judges on the Board of Immigration Appeals, forced them to become regular immigration judges, and appointed conservatives. Those people apparently were not conservative enough for the Trump administration, who expanded the board to 23, got rid of many of them, and appointed even more conservative people to the Board of Immigration Appeals. And of course, as we know, had an attorney general, two attorney generals, both Sessions and then Barr, who were issuing for the first time an extraordinarily large number of opinions directing the Board of Immigration Appeals, where they felt they wanted to kind of shut down the possibility of people being able to ask for relief by saying you couldn't get continuances, you couldn't administratively close an immigration case over a period of time. So that was going on the immigration court side. And then the bureaucratic side. And this is the last point I'll mention about the administration. The bureaucratic side is something I think people really didn't understand, because we tended to blame everything on COVID. And that's actually not what happened with the group of people in the White House led by Miller. What they did, quite simply, was they stopped funding the Department of State. They stopped accepting monies that were used to fund USCIS. There were warehouses full of applications with checks. You know, USCIS is self-funded. So the government always used to rip off that check, put it in the bank right away so they would have money. They strategically bankrupted USCIS, and in 2020, as you may know, went to the Congress and said, we don't have any money, give us $1.8 billion. And they did it on a single piece of paper, knowing, and this is how smart these people were, knowing that the Congress would never, and never has, given money to an agency simply when the agency gives you one piece of paper with no justification and says, give me $1.8 billion. So what they were in effect doing is bankrupting the system. That's why when we talk about delays, a year delay now for employment authorization, a year or more delays at the consulates, it's because when the consulates were suffering attrition and people were leaving, they refused to hire anyone. And the idea was, you know, there's lots of different ways to end immigration. It's not only legislatively, you can just slow it down to a halt. And I always remember one of the papers I first wrote when Trump came in 2016, I said, he's going to do what President Hoover did during the Depression, which was he called all the consular officers together and said, you need to strongly enforce the public charge provision. And as a result, there was a 60% drop in the numbers of people coming to the United States. So that was their playbook. The playbook was, how do we slow it down to a halt, grind it to a halt, and end immigration into the US? Okay, so
I have a question, Ira. When you, you're clearly very involved, politically and with your PAC and talking to both sides of the aisle. And I think some of these moves can be, defensible on different ideological views. But when I'm having this conversation about talking objectively about how difficult it was to practice immigration law the last few years, I point out examples like, green card applications having a blank instead of an N/A and getting denied for those reasons. or an H-1B petition, getting a request for evidence when you're basically just resubmitting the whole packet. There was actually nothing deficient.
Right.
How do, when you talk to the other side or the bureaucrats who are putting these policies in place that are just not political, they're just indefensible, I think. What do they say? What's their response? What was
Well, I think their response is always the same, that, you know, we have a heightened standard for what we regard as, you know, a good application, and we are kind of putting the alien to their test. And, you know, in some theoretical world, I suppose that's defensible. You know, you can always say, you can give me more evidence of that national interest waiver, or we need more evidence that the I-130 is a bona fide marriage, or we need more evidence on the ability to pay on an I-140 petition. But I really think the word was very clear coming down from the top. And by that, I don't mean Trump. I mean the people in immigration, really coming from Miller and others, who were basically saying, okay, let's put them to the test. The only thing we're really concerned about is fraud. So everything else is secondary. And, you know, this is an interesting, for me, it's a very interesting view of how you treat any agency. For example, even before Trump, before the Republicans, when the Democrats were in office, I don't know if some of you were practicing then, but there was a issue about naturalization. You know, we get hundreds and hundreds of thousands of applications for naturalization a year. The government found that out of those hundreds and hundreds of thousands, 6,000 people had lied on their applications and not put in their criminal backgrounds. And the government then entirely changed their view of how naturalization applications should be done. And I don't know if you remember, they had to have FBI checks and so forth. And as a result, the numbers of people who became naturalized and citizens dropped dramatically. So there's always a balance. You have to balance how many, yes, there'll always be some fraud, but there's no such thing as zero tolerance for fraud, because if in fact you have zero tolerance, the whole system stops. And so there has to be some kind of rational and reasonable balance. And I think what happened in the last 4 years is said, no, it's a zero tolerance policy. And not only that, we expect you to provide much more evidence than you've been providing before. And as a result, it's like what you're saying, Mala. I mean, you know, applications being sent back because a box wasn't checked. These are all techniques designed, if you believe malevolent intent, they're designed to crash the system and just slow it down. If you believe that they just want to make everybody jump through every single hoop, then it has the same effect anyway. It's just that it may not be for a malevolent intent, but you know, I think that's where we're at. It's the same thing with employment authorizations. Employment authorizations become meaningless if people have to wait a year to get a work authorization. I mean, how do you deal with that? I mean, you submit an application. Remember, they're only given 180 extra days if you submit it timely. And if it's taking a year, we all know as practitioners that we have to tell our clients, well, you have to stop working until you get the employment authorization because it's been more than 180 days. Now, that originated during, you know, the last administration. And I believe that that was a conscious decision to slow it down with employment authorizations, et cetera, to make it extremely difficult for people to work in the United States. And they know full well that working in the United States is a major aspect of business immigration, asylum, and a number of other things. So I think what's really happened is on an administrative level, forget about the legal issues and so forth, but just on an administrative level, the system is not functioning now. And the question is, can the Biden administration bring that back or not? I mean, you know, Biden comes in, he ends the Muslim ban, he ends the travel bans, but then he replaced the travel ban for South Africa. Regulatory changes. They dropped the health insurance requirement. They dropped the stringent requirements on EADs. They're settling a number of very important lawsuits. I don't know if you've been following that over the last, you know, let's say 6 months, but they are actively and clearly trying to settle a lot of cases in the favor of non-citizens. I mean, one of the cases we've been working on for 5 years involving the fraudulent University of Northern New Jersey. We just settled that case with the government. I've been trying to settle it with them for 5 years and we didn't get anywhere. And all of a sudden they become much more receptive. And that's going to have an impact on 1,000 people, mostly people who the South Asian Bar Association probably represents. So that's an aspect of how they're trying to do things. They're ending and now submitting new public charge regulations. They're trying to do administrative fixes at EOIR and ICE memos. The AG has reversed now matter of Castro-Tum and restoring the old standard for continuances. They have vacated matter of AB, which was the decision basically saying there's no asylum if it's what they considered a somewhat personal dispute. Matter of LEA that said they vacated nuclear families would not constitute a social group normally. You know, the former Attorney General Barr took that position in matter of LEA. They vacated that. And they vacated the decision prohibiting stipulations in asylum, which is a big factor for those of you who actually practice and on a daily basis and see what the courts have done. They've also, I'm sorry, go ahead.
I had a question. With all these changes, it sounds like they're trying to get everything back to the way it was beforehand. Do you think that will also increase, hiring more officers to get rid of the backlog and get some sort of funding that will help move things along, like the EAD delays that still continue?
Yes, and one of the interesting things I was looking at yesterday in the House version of the appropriations bill, they were going to give $345 million to USCIS to deal with the backlog alone. They were kind of directing them on asylum for employment authorization. So there are changes that are in the works. The problem with all this, of course, is how long it takes. It took, the Trump administration 4 years to get where they were. This idea that Biden was going to come in and change everything, I think, was just not realistic. I think the agency, first of all, if you tell agents you're rewarded for finding fraud and not rewarded for approving anything, that sets a mentality that needs to be changed in the agency. That we want to give people benefits who are entitled to those benefits, and we want to make sure they get those benefits, and we will reward officers for doing that, for getting quotas done, for approving applications. So that, that's kind of part of the the overall administrative problem. The other thing is, yeah, go ahead, Mom.
In your opinion, are we trying to get back to where we were before Trump? Because Obama was highly criticized for not really successfully reforming immigration. Or are we trying to get to a different point of unknown? Or is it a little bit of both?
No, I was going to discuss that as well. And in kind of a
Sorry.
bipartisan way. No, I don't think we're making any real progress in the sense that we're going to see dramatic changes that would really help our clients. I think the struggle now is simply to get back to where they were. And even then, I think there are problems. Now, they've tried some workarounds. For example, the whole STEM issue is an effort to, and I was going to talk about that a little bit, to kind of work around the H-1B problem. But a number of the things that we would like to see changed are legislative changes. And immigration has now become, I hate to say it, but like abortion. I mean, it's become a hot button issue. The Republicans believe that they can run on this issue in 2022 and 24. And the Democrats are running away from immigration. So, you know, the kinds of things I think that we would like to see in major changes, I don't believe is likely to happen. I think if we can get back and maybe have a few modifications, and I was going to talk about those administrative changes, the kinds that you were talking about before that make a big difference. For example, I've been to the Obama administration, the Trump administration, on something that's very simple. If you have an application that's denied and you appeal it, or you have an application that's denied and you file a motion to reopen, that time period is considered unlawful presence in the United States. So that you file, your client's L1 is denied or their H1 petition's denied, and you file a motion to reopen, that doesn't stop the clock. So unlawful presence begins to accrue. And as we know, it takes some months and sometimes years at the AAO or otherwise to decide those. For years now, I've been trying to get them to say administratively, that time period should not count as unlawful presence. So there are different things that you could do that would help clients. And we have a whole list of them that, you know, if we have time, I'll get to talk about. But I think those kinds of changes, Mala, are the ones that I think we're more likely to see in this administration. But the major systemic changes that we really need, you know, dealing with DACA, dealing with TPS, dealing with the fact that we don't have enough visas in either business or family, are just not likely to happen, at least in the form that we would like it to happen. So, although there may be some things, and let me just talk a little bit about some of those things that they've already done. For those of you who want to know what they've done on STEM, look at 87 Federal Register 3317 that was issued on January 21st, 87 Federal Register 3317. That has now included 22 new categories for STEM. And it's obvious that what they're trying to do is kind of do a workaround on H-1Bs to say somebody can be in STEM. And so now they're including climate change, forestry, business, financial and data analytics, industrial and organizational psychology, social science research methodology, quantitative methods, and other areas. But I can tell you already, Senator Grassley today or yesterday is demanding to know why some of these areas have been put in STEM. He doesn't regard those as, you know, STEM areas and so forth. So we're even going to have a fight over that. But this was clearly an effort to try, let's see how we can expand the group of people, how we can get them some kind of benefit where they'd be able to work. And what's the reason? The real reason is not to benefit immigration, it's to benefit the country. That is, you know, and that's the problem of both Democrats and Republicans. So I'll be bipartisan here. I mean, the real problem is we have not done a good enough job of coming back to the roots of what America is about, which is America is about immigration. We can't survive without immigration. And I don't only mean the high tech people. As I always point out, often when people say, well, we should bring in people who have PhDs, which we should, but I always point out, and I always say the one word, Google. And the reason is that Sergey Brin, the founder of Google, one of the two founders, came into the United States as a refugee. He didn't come in as a PhD. He came in as a young refugee with his Russian parents. So, we need immigration from a lot of different sources, a lot of different parts of the world. And I always tell people, I in many ways are kind of the living embodiment of that immigration. My father came to the United States at 12. He left his country at 12 years old, came to the United States, had a 5th grade education, and had 4 sons, 2 lawyers, a doctor, and an engineer. That's the American story. And that's the thing that we have not done a good enough job, I think, of convincing people.
I want to kind of go back to the STEM, because I feel that STEM it's almost like a neutralizer, even though Grassley's had questioned some of the categories that have been added to it. But do you think STEM could actually be something that will, bring people together, bring the two parties together to allow it to move forward? Because there's a win-win at several levels. Do you think STEM will create that, the opening or beginning of some sort of change? Because I feel very encouraged about these additions.
Yeah, I think you're right in some sense. That is, I think the way you're going to bring both groups together, that is the pro-immigration people, ironically, they will come together because there'll be pro-immigration and anti-Chinese responses. And that is what I think we have in the act that is pending in Congress right now, that has passed the Senate, that has many provisions and features that are, how do we become competitive with China? And I think there's now a recognition, it's not necessarily anti-Chinese, but I think there's clearly a recognition that we need to be competitive with China, and we're falling way behind. So STEM, I think, Hamel, I think you're right. I think that's one of the areas where we may see more cooperation, in the recognition that if we want to be competitive and stay competitive in this world, we're going to have to actually do a lot more than we've done before. The Congress has passed it in the Senate. They are appropriating much more money. We can talk about some of those provisions as well. One of the provisions in one of these bills would exempt STEM, right, from
To green card.
STEMs with PhDs would be exempted from numerical limitations. I think one of the ways we're going to get there, and I think you're right, this is a good point. One of the ways we're going to get there is probably not adding visas, but probably exempting people from numerical limitations. And as you saw in the Build Back Better bill, that was the strategy. That is, we would allow people who want to pay a fine and who are in EB1, EB2, EB3 categories to kind of jump the line in some sense, pay a fine, but that they're getting it would not have an adverse numerical impact on everyone else. And I think that's the strategy. And I think that's a reasonable strategy. I mean, we at Immigrants List have been working on that. with the leadership in the House and Senate to try and get them to see the need for more visas. My big thing has always been don't count derivatives.
Right. That would be
Mhm.
great if they
Uh,
didn't count the derivatives. That
Right.
would free up a lot of numbers.
a huge number of visas would be available, I think, if we didn't count derivatives. So anyway, on the STEM, so, what have they done? As you know, in the last couple of months on the policy manual, they've loosened up and made it easier for people in STEM to get NIW, national interest waivers. They're establishing new college and university internship programs for STEM. They've developed an entrepreneurial program in two respects. One is the program that they already have, the parole program, to make it easier. I have to say, I'm not a big fan of it. I don't think it's the entrepreneur parole program, or even the parole program that they're suggesting with the new W-1 visas in the Competes Act. I don't think is going to be very successful the way it's structured. But there are things that we can do on that. I mean, in EB-5, obviously, there are much more that should be done for the individual, right? The direct investor, not so much the regional center, but the
Right.
direct investor, and a path to residency for those people. So
And
that's
how do
what,
you think, I'm sorry,
Yeah.
how do you think that compares to, while we want to be competitive as a nation, there are other countries that have very different types of ways that one can immigrate. Like, for example, in Canada, it's a point system. And do you think that there would be changes? It also allows people to invest and immigrate to other countries. Do you think that we'll adopt those types of changes to make us competitive overall, globally?
my sense is that they're not going to have a point system unless they do something with family immigration too. That's the big fight, right? I mean, the people who want more business are met by the people who say, the backlogs are ridiculous. I can't, I'm a US citizen. I want to bring in my adult child. I have to wait, 8 years now, 9 years. I'm a resident. There were a number of, I think, smart suggestions that would have helped both. For example, treating lawful permanent residents as immediate relatives would have changed a good deal of the problem. But, the trade-off is really the issue. So, personally, I'm not a big fan of the point system. I don't think it necessarily helps. I think our problem is not that we can't attract people. We seem to be doing very well in attracting people. It's just we don't have the visas to give them. I mean, the situation with Indian nationals is absolutely intolerable and ridiculous. I mean, we should have said years ago, just take them out of the quota. If they want to pay $1,000 extra, or the employer wants to pay, make them a residence, allow them to adjust. If you have a master's degree or a PhD, allow people to adjust. It's not the categories, in my view, as much as it is the backlog. And so the issue is how you deal with that backlog. And, honestly, I mean, I don't want to make it a partisan issue, but the truth is, for 30 years, Republicans have said, we don't want one more visa, not one more visa. And the Democrats, instead of pushing and making it a public issue and saying why it's important, but we now may be at that point. You may be right. We may be at the point where we feel so far behind China in terms of development, National Science Council, other things that we're doing, that this may finally propel them to actually agree. And I think if they do, they're willing takers on both sides.
I mean, certainly the labor shortages are nonpartisan. There's a huge labor shortage and there's a huge pool of applicants ready for them. So
Right. And that's another issue I was going to touch on, which is I think they're going to expand, and I think there is bipartisan support for H-2A and H-2B workers. I think there's going to be a lot more. I mean, for those on the call who are interested in, just from the business side, learning to do H-2As and H-2Bs may be a good thing at this point, because I think that business is going to expand. And you saw in the last 2 years, the irony, of course, with Trump was no immigration except 30,000 more H-2Bs. The first 2,000 went to Mar-a-Lago. So, there is a desire to have non-skilled labor. And, and everybody knows we've needed it for years in farm work. I mean, there's never been a question about it. And the way they've dealt with it is just not to enforce employer sanctions, to look the other way, and pretend everything is still the same. But, the reality is we need large numbers of H-2A and H-2B workers in the U.S. And whether or not they'll do it, I think you're going to see more numbers in the next couple of years, additional appropriations for 30,000 more H-2Bs and so forth, just like we've seen. So I think that's going to happen. But that doesn't solve the strategic problem that we've been talking about in terms of high-skilled workers. We need to solve the problem of Indian nationals having these ridiculous waits. The way to do that is, what we've said, which is you don't want to add new visas, fine, but allow them not to be considered part of the quota. I opposed, as many of you may know, I oppose the idea of using the quota to satisfy Indian nationals only because I thought it was destructive for the rest of the world. I mean, and not that Indian nationals don't deserve it. It's clear that they do, and they shouldn't have to wait. But the solution isn't to pit one group against another. We have to find
Absolutely.
Okay, and then some of the other administrative things they've done, and this is something I think everybody on the call, to the extent you do business or even family, they came out with this transfer policy in the last week or two, where if you have a pending I-485, you can basically transfer it from any family or employment category. The reason they're doing that is because of the bureaucratic crashing of the system. There's 140,000 extra employment-based visas this year. So the idea is if a client has a EB-2 pending and visas are available in EB-3, just file that petition and transfer it to the pending adjustment case. If there's an adjustment application, because sometimes, those adjustment applications have been sitting there for years. They file them and then it backlogged, right? It retrogressed. So what they're saying is, and they've said it publicly, we have 140,000 more visas than we expected. EB-5 visas, which also weren't used because of the end of the regional centers, have gone to first preference in EB-1. So those are available. So I would urge, anybody, looking at these numbers to get online as fast as they can on that. And then, the other change, of course, was on the Afghan treatment. The president, the Congress, actually, this, we were talking about bipartisanship. This is one of the few bipartisan areas. They provided 34,500 special immigrant visas, which was a substantial increase over what they had before. They are also making it easier for adjustment of status for spouses and children. And as you know, they started that, the program, Operation Allies Welcome Program. And they basically said, look, if you're from Afghanistan, you can come in and apply for asylum, you can come in on a parole, or you can come in on a special immigrant visa. on all of them, you're going to be given benefits. If you come into the US, you're going to be given a work authorization and so forth. So I think that was another way in which, you know, this administration, at least administratively, are trying to do things. EB5, I know you folks asked me about EB5. Who knows? I mean, we're going to find out next week, right? I mean, we're going to find out by March 10th or 11th. Senators Grassley and Leahy, other than Schumer and McConnell, the two most senior and most powerful people in the Senate, have been working on their EB5 bill in secret. It's probably going to look like a lot like their last EB5 bill. I think we're going to have that Hobson's choice of either accepting that bill or not having anything. I don't think they're going to be influenced one whit by any of this litigation that's going on or anything else. I mean, nobody's going to roll Senators Grassley and Senator Leahy. They're going to get what they want, or they're just going to walk away. So I think we'll know, you know, within the next 2 weeks, do we have a regional center program or not? If we don't, the agency has said they're going to start presumably adjudicating the cases, denying them. And then it's going to be an interesting fight as to whether or not the regional center program actually was not legislated. You know, that's the issue now. 2 lawsuits have been filed. We plan to file a lawsuit in our own case, where the argument essentially is that when they deauthorize the regional center, they only deauthorized visa numbers. They didn't deauthorize the program, so that the agency was wrong in not going forward and adjudicating the cases. Okay, on H-1Bs.
Oh, I have a quick question. Do you think
Yeah.
that the EB5 numbers, you know, the investment numbers, how they increase, do you think they would go back down to the 500 and million? Or do you think they are going to stay where they
Well,
are?
there was litigation. It's back to the 500 now because they stopped the increase from 900 to 1.8 million. There's talk about making it something like 800 or 750,000 on the low end, 950,000 on the high end. So that may be the compromise that they strike. You know, I'm not sure whether it will make a difference at this point, but certainly keeping it at that 1.8 million, I think, was an impediment for people to join the program. Okay, let me just talk a little bit about H-1Bs. How do you get around the problem? I know you've been asking me for South Asians, you know, the typical is F1. We've been doing this for 40 years. F1 to H-1B to what we used to call labor certifications, now PERM, right? And how do you resolve that problem? Well, I think one of the things they were trying to do is this notion of early filing, right? In the Build Back Better bill, you know, if you file early, at least you get a work authorization and you're here, even if there's a backlog. But the other was, as we said before, not counting people in the quota and just giving them residency if they're willing to pay a fine. I think that's how, I don't think we're going to see major changes in H-1B. There's too many.
And I think this is where STEM can be instrumental. I really do, where you have somebody that graduates, you know, on the F1, does a STEM for 3 years, and then they hit the ground running because they can start filing a lot sooner. So I think that I'm loving this whole STEM thing. That's just me. But I think that might be something that would work or help at least alleviate a little bit.
Yeah, and if you look at where this administration is heading on that, I think it's clearly in that direction. And I think part of it is they have a lot of pushback on H-1Bs from the unions and so forth. So they're not likely to kind of get more numbers on H-1Bs.
Sir,
And then there's some other, my big thing is, and I think I've sent you folks the list. I don't know if that's been distributed about immigrants list has two things. One is we've had 7 major statutory and legislative changes. And the other is lots of administrative changes. And one area that I think is ripe for administrative change is this idea of being out of status through no fault of your own. The agency very narrowly interpreted that. They've even narrowly interpreted to say if a lawyer commits malpractice, it's not necessarily through no fault of your own. You can sue the lawyer, but that's your problem. I think there's lots of things they can do with that and play with it. And I think everybody on this call should think about these kinds of things administratively. And the reason why I say that is we all practice. We see these little things that nobody in Congress ever sees. And many of the people in the agency don't understand. I mean, and, to the extent that you can come up with expanded definitions for the criminal, the people who do defense, immigration defense and criminal, I've been pushing, why don't we just redefine custody? Because the Supreme Court this year, I believe, is going to end any hope of people not being detained. They're going to read every statute to require detention. And then they're going to say you can only parole people on a case-by-case basis. The anti-immigrants have already started. As of today, they issued some long statement about how parole has been misused because they know that the Supreme Court this term will basically shut down, I believe, any hope of people being released. And so the only alternative is parole or a redefinition of what custody means. In other words, the statutes say detained or they say custody, but what does custody mean? Under habeas corpus relief, custody is very broadly defined to include things like ankle bracelets or reporting requirements or anything where you're still under the supervision of the federal government. That's custody. You don't have to incarcerate people to have custody. And so that's another area where it seems to me if we're creative, we can start to think about how we come up with administrative solutions. If you file, and the same thing, by the way, although there's some danger to it, is in a status not authorized by the Attorney General. So what is a status not authorized or a status that is authorized by the Attorney General? If you're fighting a removal proceeding, they've said you're not in a status authorized by the Attorney General unless you win. Well, why is that so? I come here, I'm put in a deportation proceeding. I may not, I may be, by the way, you can be put in a deportation proceeding now under the current definitions. If you file an extension of status on your tourist visa or your H-1 and you haven't heard and your H-1 or your tourist visa expired, you can be put in a deportation proceeding. You may not be subject to 222G, but you could be put in a deportation proceeding. And if you're in one, that time is not authorized by the Attorney General. But why is that so? Why is all the appeal time not authorized by the Attorney General and so forth? So I think people need to really think creatively about these things to get around the 3 and 10 year bar. And, I guess I've been practicing too long, but the reason why I say that is when you practice before 1997, the volume of practice increased. Before 97, it was substantial. I mean, you could do a perm for anyone. And the only penalty was they would have to go home for 2 weeks, get their immigrant visa and come back. And now, of course, as you know, whether it's second preference or a perm, if they're not in status, the danger is that they leave and they can't come back for 10 years. So nobody does it. And, you know, this is a pitch I've made to members of Congress. The idea of the 3 and 10-year bar was designed to prevent people from staying here illegally. It's had exactly the opposite effect. We have 11 million people in the United States, most of whom could have been residents by now through a labor certification or the PERM process, because before 1997, they would just go home. And, you know, to pick up on the point that Mala and Hamel said, you know, the shortage of labor in the US, one of the ways to deal with that is not to have a 3 and 10-year bar. All those people can go home. They can get a green card. I mean, you know, home health attendant, particularly in the health field, home health attendant, people taking care of children in the home, people taking care of elderly people in the home. We used to make those people residents all the time.
Yeah.
And they would come back and there would be no problem. So that's another area I think we've got to figure out, and that's been our priority since we started Immigrants List, to get rid of the 3 and 10-year bar.
Ira, there's a question in the chat from Doralina Luna. How can we convince USCIS that the 9B bar runs inside the US?
Interesting. And there have been some well, there's two things. One is if you get paroled back into the US, you're not subject, apparently. There have been some cases now suggesting if you come in, even if you made a material misrepresentation, in other words, you went home, you lied, you got a visa and you came back, and then the 10 years ran here, there have been some unpublished BIA decisions suggesting that you've fulfilled your requirement under the 3 and 10-year bar. So, but you're absolutely right. I mean, that's another way of looking at it, because there are some decisions now, unpublished, but you should look at them, that are basically interpreting 212A9B and saying it doesn't require you to be out of the United States for the 3 years or the 10 years for it to run. So whether you came in EWI or whether you came in on a visa or whether you came in on parole, you would be eligible and not any longer barred by the 10 years. But it's like anything else, you know, somebody's going to have to win that in court unless we can get them to change their views. I will say, we have the best shot now than we will have for many, many, many years of changing the views of the people in the agency. You know, I know a lot of those people. They are very pro-immigration. I think they're overwhelmed by the job that they have now. They have no money. They have all these huge backlogs and so forth. But I think for many of them, their heart's in the right place in terms of trying to do the right thing with people who are undocumented and so forth. So I wouldn't give up. I mean, you know, for those of you in Republican districts particularly, or have access to Republicans, I'd start to pressure them. And the way you do that is you give them examples. And the one good thing about us, we have incredibly sympathetic, right? All of us have incredibly sympathetic examples. And I think you need to bring those to the attention of your member and say, please try and do something about it.
All right, you know, can you speak to the immigration industrial complex and how that comes into play? Because there's so much that's going on. There's a lot of sympathy, there's a lot of empathy, but it sometimes I'm just surprised at why somebody would vote in a certain way. And you know, it's always that, oh well, there are other things, or this industrial complex. Can you comment on that?
Yeah, that's my favorite. I have to tell you, now you really start. It's my favorite topic to talk about. In two respects. One is the consolidation of information. I don't think, and maybe because I'm just a nerd about, my book and reading everything, so I read these things. But I just want to give you some examples of the consolidation of information now within Department of Homeland Security. They have a biometrics and background check. It combines all checks to allow DHS, quote, to collect and maintain biographic, biometric, and background check records on applicants, petitioners, sponsors, beneficiaries, and others who make benefit requests. So they are consolidating this huge amount of data on everybody, applicants, petitioners, sponsors, beneficiaries. Then there's the Citizenship and Immigration Data Repository. It has the claim system, the RAP system, the APSS system. I don't know if you know any of the RNAC system, the SysCore, the CIS system, and FDNS records, for fraud, all in one system now.
What
DOS,
about the DOS, when you're the latest social media?
Right, the DOS collection of data now, you have to give them all their what is it? The social media handles. And the Biden administration, and this is one of these things, we always talk about bipartisanship. The things that are bipartisan are the worst things. This is bipartisan, okay? I mean, they all love gathering this evidence. So the Biden administration announced recently they were not going to change that policy, that people were going to have to give their social media and so forth. And then on DOL, all files of employers who file labor certs, labor condition applications, prevailing wage applications for either permanent or temporary employment of foreign workers, and all the information on agents and recruiters, all in one system. So I don't know what we can do about it, but it's huge. And then we get to my other favorite part of this is the immigration industrial complex. ICE's budget, they asked for $8.3 billion this year. They're going to probably get 7.9. HSI, it is now the second largest investigative agency in the United States, I suppose only to the FBI. They are mandated to have 32,500 people sleeping incarcerated. They call it beds, but it means incarceration. CBP asked for $16 billion this year. They're going to get 14.7. 120 million for border technology, 655 million for walls and fences. And, there's just no end in sight. And why is this so frightening? It's because I think about what you were, hinting at. They are doing this just like the military industrial complex. It's all over the United States. So it's in rural areas where there's not a lot of employment, in jails, in county jails, city jails, rural jails, where they're paying people. And this year, just to show you how outrageous all this is, this year there was a Congressional Research Service study that said that they were losing $22 million a year on paying these jails and cities, and nobody was being detained. So 22 million was coming out of the CBP or ICE budget. It's like a bribe, basically, to keep your jails open in case we ever need them. And that's, to me, the real fear, that this will become so embedded, the technology part will become so embedded at the border with drones and everything else. And I'll tell you one sign of this is GEO. GEO, as you know, is one of the two private prisons. They see that there's a big push to end incarceration of immigrants in private prisons. they have announced they're moving more into the technology field. Well, what does that mean? It means they're going to develop technology at the border of the US. And we know that means the southern border. Definitely doesn't mean the Canadian border. And why are they doing it? Because that's where the money's going to be. And we are just spending a ridiculous amount of money, really for no reason, at the border, because there's now all these companies vying for contracts, just like the military industrial complex. And I think that's it. That is probably the most difficult thing to break, because both parties are in on it. It's really kind of a bipartisan
It
way of.
really is. And it's all those metrics that you listed. It's kind of frightening, with how everything gets pulled together. But then you think you come across something where you have a border patrol agent, has the latitude of expedited removal for 5 years or something, where they say, oh, we didn't have the data, but they do.
Right. Right.
And so I think there's in terms of 3-year, 10-year bar, doing away the discretion of expedited removal, where there could be a lot of misunderstandings resulting in a 5-year bar that may not necessarily be, or a lifetime bar that may not necessarily be justified.
Right. They do a 212A6CI, said you made a material misrepresentation at the border. It's not 5 years, it's out forever.
Yeah.
Okay, and then the just a couple of things on the appropriations bill in the House. There is some good news. They want to have money for the children who've been separated from the families, to try and bring them back. They are appropriating money to end the FOIA backlog, or at least reduce the FOIA backlog. Providing money for humanitarian medical responses to surges at the border. In other words, they're looking at it not as just an incarceration issue, but as a humanitarian and medical issue. They're resuming joint task force, which apparently were ended under the Trump administration. They're giving more money for oversight of ombudsmen for detention, because, as you know, there are more and more people dying in detention who have COVID-19. So they're appropriating more money, more staff for the ombudsman to oversee any problems with people in detention. They're going to do some oversight over the technology that they're using at the border to see what that will result in. Use of force policy, as you know, some of the horrors we've had at the border, including the shooting of that 15-year-old kid that went to the Supreme Court, and the Supreme Court said you can't bring any action because the kid was on the Mexican side of the border. More money for asylum processing at the border. They create criteria for migrant families remaining together, which is important. Issues of abuse of 287G. 287G is the program where the federal government trains state and local people. They want more oversight on that. Body cameras, which I think would be the best thing that ever happened to ICE and to CBP. And as I said before, $345 million for backlog in USCIS, and changes on asylum, EADs for asylum, to overhaul that and to get people to employment authorization quicker. And then the two bills that I think are of some interest, which is the Competes Act. Let's talk about that. That's HR 4521. That has some chance of getting some of this through, actually. I don't think the other bill, Dignity, I put on here dead on arrival. But
Don't
the
think
compute-
E-Verify will be made mandatory for employers. I know that's one of the pieces
Right.
there. Do you think that might survive?
I doubt it. I don't think the Dignity Act has a prayer of passing. Really, who knows? I mean,
I
as I
don't
said,
think
I've
4
been,
detention centers at the border is going to be enough.
Yeah, I agree on that. I just thought that the only thing that might survive out of that is the making E-Verify mandatory from an enforcement, because they seem really keen on it, on enforcement, and that might I think that might be one thing that may get some traction. I agree with you on all the other points. I just don't see, I think dead on arrivals are great.
and I think the problem with the Verify is the other side's going to want something for it. And the question is whether or not they're going to be willing to give up something.
Yeah.
Get that. Okay, on the Competes Act, one of the interesting things I thought is they're going to add $2 billion to increasing DOS personnel in the Indo-Pacific region. Most of that is probably not going to go to visa processing, but some of it will, and that will be a huge help to bring back the consulates to the level, at least, that they had pre-Trump or at the beginning of Trump's term, so that hopefully we'll start to get some normalcy out of it. They're talking about TPS for Hong Kong residents. Treat Hong Kong as a separate foreign state for numerical limitations. Special immigrant status to 5,000 skilled Hong Kong residents per year. They may do that. The W visa, which I don't think is going to go anywhere, but it might. That's the entrepreneurial visa.
I agree with
W1.
you.
Huh?
I agree with you on that.
Yeah. There's a W1 for, this is like the old, what was it, E6? Though Lofgren had this before as a EB6. They were going to do the same kind of thing. Here they're making it as a non-immigrant visa for startups, and then essential employees of startups, and then spouses and children. But, it gives people these visas up to 8 years. I don't see the attraction in it, quite frankly. I don't think people will do it. Before, as I said, they will exempt STEMs with PhDs from numerical limits, which is a possibility and may be a good possibility. And then scholarships for STEM and improving STEM education.
Do you think when they say that, do you think that will allow producing Americans and more STEM graduates here?
You broke up there. I didn't get that.
Oh, I'm sorry. Do you think with the STEM that it'll help our education systems to catch up, and will produce more STEM graduates within America and kind of create a balance of playing field?
Yeah, I think it will. But remember, these are STEMs with PhDs. So not with master's degrees. But I think it'll help somewhat. I think there's no question about that. And that's something that we clearly need. So let me just go briefly over what we've been trying to do in Immigrants List, just to give you, just to give everybody on the call just some ideas. And obviously we're open to any ideas and people participating and volunteering. And if you're interested, or even if you don't want to be involved, talk to your members of Congress. Let them hear the other side. It's what we were saying before. All they hear is, everybody's a criminal, everybody's coming to take jobs, even though it's all ridiculous, it's all fantasy, but that's what they hear every day. So they need to hear the voice of reason. And I think we have more to say about it than anyone else. So the 7 things that we've been trying to advance over the last year or two are obviously eliminate the 3 and 10 year bars and expand the availability of waivers. You know, one of the brilliant things that was done in 1996 and 90 in the Illegal Immigration Reform and Immigrant Responsibility Act was they knew that they couldn't do away with waivers. And this was a bill basically written by FAIR and people supporting, you know, anti-immigrants. They knew they couldn't just say we're doing away with waivers. So they just modified 212H, 212I. They took away 212C and replaced it with cancellation. But just to give you an idea, 212I, Hamill, you were talking about, well, at the border, they can say that you committed a material misrepresentation on entry. Well, under 212I, originally, it was just that entry. In other words, you were just barred in that entry, and then you could come in again. Then it became, you're barred, but you have to show hardship. You're permanently barred, but you have to show hardship. Then it became, you have to show extreme hardship. Then what they did is they put in the word extreme and they took out the word child. And by making those two changes, they reduced the possibility of getting the visa by 70%. Because the truth is, most people rely on a child, right? The hardship of a child to show that you need the waiver. You can't do that in 212I. And then they took that and did the same thing for the 3 and 10-year bar waiver. Remember, there's no waiver for a child's hardship in the 3 and 10-year bar. It's only a parent or a spouse. And the truth is, if you have a parent or spouse, most of the time, you don't need this waiver. You're not going to have a problem with the 3 and 10-year bar. Because if you have a spouse, you can adjust in the US. So they knew exactly what they were doing. Anyway, so we're talking about eliminating the 3 and 10-year bar and changing the bars, allowing for adjustment of status. And here's something that I feel very strongly about and wrote, you know, some new legislation on this. You know, adjustment of status was always regarded as a special benefit for 50 years. In other words, everybody went abroad to get their visa, but once in a while, we would allow people to adjust their status in the US. And of course, now it's completely different, right? I mean, adjustment of status is really, you know, one of the, it is the major way of getting residency besides an immigrant visa. And it's a source of a substantial amount of money for USCIS. Well, why is it that a lot of people can't adjust? They can't adjust because they're out of status or they worked without authorization. If Congress eliminated 245C2 and C8, those are two of the bars that prevent you from adjusting, you could adjust in the United States. That would make a huge difference for many people who are not immediate relatives. It would probably allow everybody who is an LPR to adjust, you know, their family members to adjust in the United States. It would allow people in employment who are out of status to adjust in the US. So we've been pushing that a good deal. Waivers for grounds of inadmissibility, all grounds of inadmissibility. There's no reason why we shouldn't have a waiver, for example, for a false claim to US citizenship. I've had cases, I'm sure all of you had, where somebody who is 17 years old goes to the driver's license bureau and is told, here, fill out this form. They fill out the form and they sign it. And now all of a sudden, the government, even though they never vote, the government's claiming that they made a false claim to US citizenship for the benefit of possibly voting. So this would be a waiver on all grounds of inadmissibility. Stop counting derivatives, we talked about that. Restoring judicial review. In 1996, Congress eliminated judicial review in over 17 different ways. People don't realize that they precluded judicial review. We have a case that we just argued on December 6th before the US Supreme Court because the 11th Circuit said there's no judicial review for any form of relief under 242A2BI. So there's no judicial review for adjustment of status on any factual issue, adjustment of status, cancellation, voluntary departure, or any other form of relief. And I don't know what will happen in that case, but it shows you how extreme it is. The next was to advance the registry date, which of course, has been rejected by the parliamentarian, but there's no reason, the original date was 1947. Then it was moved up to 1972. We were asking that it be moved up to the present time. And then the last one is something that's very simple and should have been done years ago, which is to put a statute of limitations on grounds of inadmissibility. I mean, why should you have a permanent bar lasting for 50 years? And again, we all have clients where we can bring these kinds of examples to members of Congress. I have a client from Canada, 43 years old. She has 3 American citizen children, American citizen husband. She smoked marijuana twice when she was 17, has 2 Canadian minor convictions, misdemeanor convictions. She's permanently barred from the United States. I mean, that's just crazy. And in country, and there's no reason why we have a statute of limitations virtually for everything in America. You take a baseball bat and you beat somebody over the head with it, and there's a statute of limitations. And yet, no matter what you do in immigration, there's no statute of limitations. So
I agree. I that there's so many lives could be changed by changing those types of limitations and bringing back waivers. I remember when I started practicing, there were quite a few waivers available in immigration. Now there's hardly any. You just go it, and it's because of people like you. You keep litigating, keep bringing it into court, that there's going to be some traction, some sort of change. And it's really important work that you're doing and bringing this to the forefront.
But I'm really imploring everyone who's on this today, go to your members of Congress with examples. It really makes a difference. And I don't care if they're Republican, what you were saying originally, I don't care if they're Republicans or Democrats. It's got to get to them. I mean, a person who smoked marijuana 30 years ago was barred from the United States. Somebody who committed a crime 40 years ago is barred.
Especially now that they're going to be legalizing it in many states, it's kind of a moot point at a certain time.
Right.
We do have a question.
Yeah.
So what would you say the top 3 to 5 positive immigration achievements of the current administration since they took office?
The Biden administration?
Yes, yes.
They're going to come out with the public charge regulations. They just did, actually, came out with the reversing the policy on public charge, which I thought would have eliminated virtually everybody who wasn't wealthy, the way that it was written. So they're doing away with those. They're going to come out with asylum regulations, I think, that are going to be quite good in the next couple of weeks or months. They are trying to use this on the business side on STEM, I think, which is a good workaround, or as good as they can get. They've ended all the major bans except for Title 42, which I think is shameful. I mean, I've been, blasting Trump and blasting this administration for Title 42, which I think is a direct violation of our international obligations to accept refugees. And the other is the reversals on the Attorney General opinions. I think, the fact that they did away with Castro-Tum, matter of AB, matter of LEA, ACAA, all of those changes, I think are significant. I mean, they make it possible to practice before the immigration courts. As I said at the beginning, I really think their heart is in the right direction. I think they're intimidated, unfortunately, by the same thing about the border. And this has been bipartisan, like our foreign policy, our immigration policy about the border, again, seems to be horribly bipartisan. And Title 42 is just, it's an outrage. After the Second World War, when people were going to, during the Second World War, people were going to countries. German Jews were trying to get into Switzerland. They were turned around at the border. People came on ships to the United States and to Cuba, the famous St. Louis. They were turned around and sent back to the gas chambers in Germany. So in 1954, the world got together and said, we will never do this again. We will never turn people around at the borders of our countries if they have a claim for asylum. And now they've come up with this bogus, and I mean it's bogus, and you really have to read the regulations on Title 42. They say, well, it's not an immigration issue. It's keeping people out with COVID. And so it has nothing to do with immigration, but that's nonsense, because if you read the Title 42 regulations, the CDC regulations, you realize how ridiculous it is, because they're not stopping people at the border who have COVID. That's not what they're saying. What those regulations say is, we've contacted CBP, we've contacted ICE, and they have told us, despite the numbers I've now told you, which equals about $23 billion a year between both, that we can't guarantee that if we keep these people in detention, they won't get COVID. That's the sum and substance of the regulation. It's not about, people coming in with COVID and we're stopping at the border. I mean, for goodness sake, we could test people at the border, right? And if they have COVID, we could stop them. But it's not about that. It's about stopping people who are trying to come in to seek asylum or refugee status in the U.S. And it's an international disgrace. I mean, it's one of those things that I'm outraged by. And I've said it repeatedly the last 4 years. I mean, it's just ridiculous that we do that. Shameful. Anyway. Now I'm going to tell you how I really feel.
Thank you for that. We have one last question, and it is, what executive action steps do you recommend the Biden administration focus on if control of one or both houses of Congress flips in November?
Okay, in terms of executive actions, we have a whole list. I don't know if you were able to distribute that list, but if you can.
We will. That list, yeah.
Yeah. I mean, I think we came up with about 30 different things, but anything any of you have, please feel free to send them to me. Things like redefining admission on the Pereira and Mies Chavez cases. The board's determinations are ridiculous, of saying that no matter what, if you have two separate documents, you can still go forward with a deportation hearing, notwithstanding what the Supreme Court has now said twice. Issuing an opinion on whether immigrant, IRs can adjust beyond the 90 days if they come in the visa waiver program. If you come in on the visa waiver program, you should be able to adjust your status, even if you're here illegally for a year, just like any other person who's married to an immediate relative. Deferred action on EAD and for PD cases, for prosecutorial discretion. We should be giving people EADs. We don't. Criminal definitions, which is something I have been pushing for years. We have the most bizarre system of determining what is a conviction in immigration. Expungements are convictions in immigration. Sealing records are convictions in immigration. Vacating a conviction can be a conviction, even though it's vacated under state law. There's no reason for any of that. They can administratively change all that by decisions of the Board of Immigration Appeals. Issues about naturalization. We've written a whole series of them, and hopefully all of you have that now. But anything you want to add, please, please, please send them to me. I'm happy to look them over and talk to you about it. Because when you guys practice, and when you practice, you see the subtleties that most people don't.
I think that's well said, and I think you will receive some suggestions. And I invite
Great.
everybody on this call to please send along your suggestions and questions. We have somebody at the helm that is really, really making some wonderful and incredible changes for our practice. And I personally thank you for all the things that you've done, all for your books, for your tutelage. We're so lucky to have somebody like you.
Thank you. It's been a pleasure to be here, and thank the three of you and everybody in Saba. I appreciate it. Anything I can do to help, I'm here.
Well,
At least
you know,
for the time being.
speaking of Ira, well, thank you so much on behalf of the South Asian Bar Association of North America for your commitment to us, for giving us over an hour and a half of your brilliance. It was honestly so educational. As someone who doesn't practice immigration law, I found it particularly interesting and educational. And we
Right.
welcome you back anytime you would want to come to talk to us about anything. And we will probably count on you as we go forward with our lobby day to discuss what we could actually support as we go forward in our immigration advocacy efforts. So
Great.
expect us to contact you. We look forward to working with you in the future. And first of all, thank you again. Thank you so much for coming on with us. And thank you, Hemal and Mala, for giving us the opportunity to talk to Ira today. And on behalf of the South Asian Bar Association, thank you, thank you, thank you.
Thank you. It's been a pleasure. Thank you very much. I hope to come back one day. Be
Sure.
well.
Be
Thank
well.
you.
Bye.
Thank you.
Bye.
Bye-bye.